Hello, everyone. Hi. Good morning and good evening, depending on where you are in the world today. So my name is Moira. I am a new addition to the Fieldfisher Silicon Valley team, having just recently joined as an employment director. And I'm very happy to be joined here today by Megan, who is a privacy, tech, and data expert also in the Silicon Valley team. So with more employees working from home than ever before, together with the rise of the gig economy and the increasing availability of sophisticated technology, it's perhaps unsurprising that there's been an increase in the use of employee surveillance and monitoring systems. In fact, according to research on employee monitoring commissioned by the UK's Information Commissioner's Office, the ICO, 19% of people feel they have been monitored by an employer. And whilst the law in the UK and Europe doesn't prevent employers from monitoring workers, the monitoring must be necessary and proportionate, and it must respect the rights and freedoms of workers in compliance with data protection law and other legal requirements. And finding that right balance can be tricky. So we thought it would be timely to speak today about current trends and risks in employee monitoring, and we're going to set out some new thoughts and refer to some new guidance. We're seeing an increase in client queries around implementing employee monitoring systems, so we thought it would be helpful to provide some practical insights to some frequently asked questions. And we're going to discuss what are the most common types of employee monitoring, what laws do employers need to consider? What are the privacy-related challenges? What are the employment-related challenges? What steps must, should, and could employers take? And importantly, what are the risks if things go wrong? And please feel free to enter any questions into the chat, and we'll see if we've got time to answer them at the end of the session. And if not, then we'll follow up with you directly shortly after. So jumping straight in to the first FAQ, what are the most common types of employee monitoring? Well, this has changed over time and no doubt it's going to continue to do so, but typically we see clients using quite a lot of productivity monitoring. So this could be tracking messages or keystrokes or using specialist monitoring software to track activity. And this is becoming more and more common and popular in the workplace. We're also seeing call recording and tracking of internet activity, so typically for security purposes. We see monitoring employee use of work devices and apps. There's badge tracking, so typically that's monitoring employee access to employer offices or work sites, and that's to keep track of timekeeping or access control. And we also see the use of CCTV, although very strict requirements do apply there. Biometric data is also sometimes used to monitor workers, so that could be fingerprints for access control or time attendance purposes. It could be facial recognition for device sign-on, and there'll be some more on that later. And there's potentially webcam footage if it's used for the purposes of identification. The ICO in the UK has recently published new draft guidance on biometric data, and that's currently out for consultation, so look out for more on that. And we're going to talk later in a bit more detail about what to think about when implementing employee monitoring systems and how to use them lawfully, use being absolutely key here. But for now, Megan is going to highlight the key legal considerations.
Thanks, Moira. So one of the reasons that implementing solutions that monitor employees is challenging is because it involves considering a variety of different laws at the regional and at local level. So before delving into the detail, I think as a starting point, it's important to note that you can't necessarily have a blanket rollout globally or even for Europe for some of these solutions, and that local laws will need to be considered for each jurisdiction in which you monitor employees. And we frequently explore with clients whether it makes sense to adopt a blanket rollout on a highest threshold basis, so looking at the jurisdictions which are typically higher risk from a legal enforcement perspective and applying that standard across the board, or whether it makes sense to follow a different implementation plan in certain jurisdictions. We've also encountered scenarios where clients have just simply decided to turn off certain features or the solution entirely in certain high-risk jurisdictions because of particular blockers, which we will get onto later. So, what laws do employers need to consider? There are 4 main buckets of laws. We've got data protection and e-privacy, telecoms, employment law, and human rights law. So starting off with data protection law, the GDPR and UK GDPR and other local data protection law will apply in most cases because there will be some element of personal data processing involved, whether that's employee name and audio-visual content for meeting recordings, employee ID badge for badge monitoring upon entry to the office, or IP and device ID, for example, for monitoring network and application security. There are also e-privacy considerations, for example, where that data is being stored on or accessed from the employee's device via the use of cookies or other tracking technologies. And telecoms considerations, for example, there are rules on interception of communications for call or email monitoring. We've then got equalities legislation, such as the Equality Act 2010, which should also be considered to ensure that the monitoring does not unfairly target or disadvantage protected groups. We've got human rights law, such as Article 8 of the Human Rights Act 1998, which concerns the right to respect for private and family life. And this is particularly important in respect of home working, where a worker's expectation of privacy is likely to be significantly greater than in the workplace because of the increased risk of capturing information about your worker's family and private life. And the important thing to remember here is that in the UK and Europe, employees do have an expectation of privacy at work. On top of all that, you will also need to consider local regulator guidance. For example, we've got UK ICO guidance, which sets out what employers are required to do, best practice recommendations and options. We've got more on that later, as well as guidance from the European Data Protection Board. So we're going to start off with looking at some of the privacy related challenges. And the easiest way to remember the privacy considerations, or the core privacy considerations, is don't fall into a trap by getting it wrong. Transparency is a key consideration. Employees must be informed about the existence of monitoring, the scope of the monitoring, and the specific purposes for which their personal data is processed. Monitoring policies and privacy notices, including the required information, must be directly drawn to employees before the monitoring commences. The purpose and lawful basis, which is the reason and justification for monitoring, must be established at the outset. Now, legitimate interest will often be relied on as a lawful basis, and an employer's legitimate interest will depend on the type of monitoring, purpose, and use case. For example, for productivity monitoring, the legitimate interest is often to ensure employee engagement and productivity are maintained. For attendance monitoring, it may be to ensure staffing requirements are adequately met. And for call recording, it may be to ensure quality assurance, but also extend to things like staff training and coaching. When relying on legitimate interests, a careful evaluation should be carried out and documented to ensure that the employer's legitimate interests do not override the fundamental rights and interests of employees, and that the processing is necessary and proportionate to achieve the business's objectives, balanced against the employee's rights. On a kind of side note, where the monitoring involves external parties, for example, a call between an employee and a customer, businesses may look to rely on a different legal basis for processing personal data of the external party to that call, and that processing is usually consent-based. While we're on the topic of consent as a lawful basis, generally speaking, consent is not an appropriate lawful basis under the GDPR for processing employee data in the monitoring context. And this is because of the imbalance of power in the employment relationship. However, some jurisdictions require that employers seek employee consent to monitor, and it's important to note the distinction there between consent to monitor and consent to process the resulting personal data. There are additional considerations with special category personal data. For example, you will need to identify an additional condition for processing. The most common use of special category personal data in the context of monitoring, as Moira mentioned, is biometric data used for authentication purposes. In some cases, it has been used for attendance monitoring, and we'll look at an example of the risks of getting that wrong when we look at some recent enforcement action later in the session. It's important to ensure accountability. Essentially, document what you are doing and why. For example, by conducting a DPIA, which is often mandatory for employee monitoring solutions. And if you're relying on your legitimate interests, an LIA, that's a legitimate interest assessment, to assess proportionality. In addition to the key ones that we've got on the slide, there's also data minimization considerations. Think about any limitations or controls you can implement in order to narrow the scope of the processing. For example, could a less intrusive approach be taken to achieve the objective? You'll also need to document the alternatives you've considered. Access and security is also important, ensuring there are appropriate access controls so that visibility of the data is limited on a need-to-know basis. Most of these privacy considerations will get flushed out in the DPIA. Thinking about it more practically, the things that we often look at are making sure you understand the scope of the tool, what features will the business turn on and off, and what data points will be collected. Ensure your policy and notices align. Is it clear about how the monitoring activity and how results of monitoring may be used? Understand how the tool will facilitate data subject rights. We've increasingly seen a rise in requests for meeting recordings form part of data subject access requests. So can the tool facilitate that? Or think about what you may do if a request covers meeting recordings. And what other privacy controls are offered to ensure minimal privacy intrusion? For example, does the business really need all the data the tool is able to collect to achieve your objective? Mentioned this briefly earlier, but implementing access and visibility controls is important so that managers can only view data for employees in their reporting line, for example, not the whole company or other departments. And remembering that use cases change. So assessing new use cases if the scope of the monitor increases or extends to a new use case entirely. So Moira, what are the employment related challenges?
Thanks, Megan. So in addition to privacy concerns, there are also quite a few employment challenges to consider. And I'm going to go through a few of them now, focusing on UK law, but it's important to note that similar and actually often more stringent employment protections apply across most of Europe. So firstly, there's the potential for discrimination, and there are various protections from discrimination which could potentially apply in relation to employee monitoring, and that's going to depend largely on how the data is used. But before introducing employee monitoring, you should ensure that it doesn't unfairly target any protected group of individuals. So that could be those, for example, with a disability, or those of any particular age group or race. And it might, in some circumstances, be necessary to consult with employees about possible reasonable adjustments to the system, and that could be done on a collective or an individual basis, and some of that's going to depend on the local jurisdiction requirements, as well as what the particular issues might be and what the adjustments might be. But even where it's not required to carry out consultation, it might sometimes be beneficial in any event to build up employee trust and to sort of iron out and address any potential issues before the system is implemented. It's also important to scrutinise any potential inherent bias in employee monitoring systems and to continue to consider this on an ongoing basis. If there is bias in the systems, then this could disproportionately affect certain groups, and that could open you up to a discrimination claim. This has been seen, for example, with facial recognition systems. So some facial recognition systems were unable to correctly identify people of one race with the same degree of accuracy as other races, leading to cases of mistaken identity. Another potential employment challenge is that disproportionate or covert employee monitoring practices could lead to a breach of contract or a constructive dismissal claim. So that further highlights really the importance of being transparent about any monitoring, as Megan has already mentioned. I've already talked briefly about consultations. So as I sort of touched on, it's advisable to check local jurisdiction requirements, and that would be in particular in respect of consulting with works councils and or trade unions. And it might be necessary to consult on the scope, the purpose, the duration of use, the collection and storage of employee monitoring data. It's also important to consider disciplinary or other measures and how they're taken when they're based on employee monitoring. But as a general rule, any measure taken against an employee, so that could be, for example, a decision relating to pay, to bonus, promotion, demotion, performance, or disciplinary decisions, those decisions should not be based solely on data collected from employee monitoring. And what I mean there is, whilst the data could theoretically be used as part of a disciplinary process, obviously insofar as the employment contract and disciplinary policy allows for it, you should also follow a fair and proper separate disciplinary or relevant process. So that might be a grievance, performance review, appraisal, disciplinary, depending on the circumstances. That process should be concluded before you instigate a sanction or a decision related to the data. If disciplinary decisions are based solely on employee monitoring data, then there's always a risk that the information could be taken out of context, and that could potentially render the decision to be unfair or discriminatory. For example, there could be an inaccuracy in the data, or there could be a legitimate explanation for it. And if such an explanation was connected to a protected characteristic, such as pregnancy, maternity, or disability, for example, then this creates a risk of a discrimination claim. Another consideration is around dismissal based on the data. So there are complex dismissal rules and protections against dismissal across most of Europe. For example, in the UK, employers must provide a fair reason and follow a fair process before dismissing an employee with over 2 years' service. And strict rules must also be followed to lawfully dismiss employees in many EEA jurisdictions such as France, Germany, the Netherlands, for example. So employment courts and tribunals could also take into account principles from the European Convention of Human Rights. So this would include the right to respect for private and family life and correspondence when they assess the fairness of a dismissal related to the capturing of potentially private information. So dismissals arising out of employee monitoring data should always be handled very carefully. You should always follow a fair process, and that needs to have taken into account all relevant circumstances and employee protections before any dismissal decision is made. It's also important to consider the distinction between workplace and private information. So it's not always easy to distinguish between workplace and private information, especially when workers are based at home, or if they use work devices in a sort of slightly muddled way for both private, personal, and work-related activities. If an employer monitors personal communications or private information, it would likely be considered excessive, and excessive monitoring can have an adverse effect on the data protection rights and freedoms of workers, and it's likely to intrude into workers' private lives and undermine their privacy and potentially their mental well-being. It's important to ensure that an employee monitoring system doesn't negatively impact employee mental health and well-being. For example, if the monitoring is likely to put the employee under constant pressure, then this could lead to stress, and in turn that could lead to sickness absences, poor morale, and even health and safety claims. So, bearing in mind those privacy and employment law challenges which we've discussed, what steps must, should, and could employers take? Well, Megan has already mentioned the UK's Information Commissioner's guidance, the ICO guidance on monitoring at work, and this was published in October 2023. And this outlines the essential steps that employers who are considering employee monitoring must, should, and could take. The guidance helpfully addresses general considerations for all monitoring activities, as well as specific considerations for certain forms of monitoring. So in particular, it addresses call monitoring, email and message monitoring, video and audio surveillance, vehicle monitoring, attendance monitoring, device monitoring, and monitoring to prevent data loss or detect malicious traffic. So if you are implementing solutions which monitor workers in the UK, it's worth a read of the specific considerations in the ICO guidance relevant to the particular activity. But whilst this is UK guidance, we also think it includes helpful practical steps which could be used across most of Europe. But please do also note that some member states take a strict stance on monitoring and have additional compliance requirements as well. So we thought that the most practical way to explore the guidance could be by way of a case study. And the scenario for our case study is this. The business comes to legal with a new solution which allows the support team to record calls for quality assurance purposes and to analyse those calls to provide training and coaching to staff. So, bearing in mind that situation, what steps must, should, and could employers take? So, what are the key considerations and steps? Well, let's start with the trap analogy that Megan referred to earlier. So, thinking first of all about the purpose and lawful basis or reason. So in this scenario, you would likely rely on the lawful basis of legitimate interests. So the purposes were highlighted in the case study, and they are for quality assurance purposes and to analyze those calls to provide training and coaching to staff. So in terms of accountability, you must take proactive measures to comply with your obligations and document what you're doing and why. So before implementing this monitoring, a DPIA, a data protection impact assessment, must be carried out, and a legitimate interest assessment should be carried out. And this is to evaluate whether the employer's interests override the fundamental rights and interests of the employees, and whether the processing is necessary and proportionate to achieve the business objectives, and that's balanced against the employee's rights and interests. And in terms of the monitoring which captures external parties, such as customers, you could look to rely on another lawful basis. So that could, in this scenario, for example, be consent. So you could ask them to agree to the call recording. So in short summary, it's theoretically possible to record the content of calls for training or quality control purposes, but this is going to be subject to the outcome of your DPIA and legitimate interests assessment. A key factor is going to be transparency. So you must inform workers about the call recording in your privacy information, such as the employee privacy notice, and that must be set out in advance of rolling out the system. So you need to ensure that you've explained to workers the purpose and the extent of the call recording. And you should also include information about the monitoring in any other relevant internal documents, such as your employee handbook. And any customers or external third parties on calls must also be informed that you are recording the call and why. And you can do this, for example, by signposting them during the call to detailed and relevant privacy information, which could be sent to them by email, or it could be available on the company website. And a recorded message is good practice for this. So in addition to the trap points, some other key considerations include prior to implementing the monitoring, you should seek and document the views of your workers or their reps, such as their trade union reps or the work councils. And you must do this unless there is good reason not to. And if you decide not to, then you should record the decision along with a clear explanation why. In terms of minimisation and fairness, you must not collect data beyond the specific legitimate purposes of quality assurance and training and coaching for staff. and you must use the least intrusive means to achieve this. So, for example, this will mean only monitoring work-related calls. You should not routinely monitor personal calls. You should have a policy regarding personal calls in place, and you should make sure that the workers are aware of it. And you could consider whether monitoring could be limited to certain areas of the business. So, for example, you could consider whether it would be necessary to monitor every single call, and whether the purposes could be met by only recording calls on a spot check basis rather than continuously. You should regularly review the information you're collecting to ensure there's no inadvertent function creep. And in terms of security, you must ensure you have appropriate measures in place to keep recordings confidential and secure, including robust passwords and restrict access to only those who need access in order to achieve the purposes. And you should make sure overall responsibility for monitoring rests at the highest senior management level, and you need to properly train anyone with access to the data. Although the intention behind the recording is not likely to be to capture special category data, depending on the nature of the calls, it's possible that you will do so, in which case you should demonstrate that your purpose for monitoring outweighs the risk of inadvertently capturing special category data. And finally, in terms of the retention period, while there are no prescribed data retention periods for employee monitoring under European or UK data protection law, such periods must be proportionate. So in practice, this means you should be able to justify the data retention period by reference to the purposes for which the data was collected. Even a relatively short retention period may be excessive. And in the AFL Keneal decision, and there'll be more on that shortly, 31 days was deemed to be disproportionate, and this was on the basis that this retention period applied to all of the organisation's employee monitoring data, and it was found in that case that the use of aggregated data would have been sufficient for the organisation's purposes. So in our case study, a short retention period and potentially the use of aggregated data might be appropriate. So that's a summary of the key considerations for our case study. It might be helpful to also note that similar considerations would apply to meeting recordings or sales calls, but I will hand back over to Megan now.
So we've talked a lot about how employers can mitigate risk and ensure they don't fall foul of compliance requirements. But what are the risks to the business, and what examples have we seen of employers getting it wrong? Individuals are becoming increasingly privacy conscious, and there is a risk that employees could complain directly to a regulator or seek to threaten such action as part of employee proceedings. So failure to comply with data protection laws could see you subject to enforcement action and fines. And up until recently, we didn't have many examples of privacy regulator enforcement action for employee monitoring activities. That has changed in the last year, and recent cases highlight the risk of employee monitoring for the purpose of evaluating attendance and performance in particular, and we'll talk about those in a moment. Failure to comply with relevant employment law, on the other hand, could result in individual and/or collective claims or complaints, potentially resulting in reputational damage, compensation, and damages and legal fees. So first up, as Moira mentioned, in December 2023, the French Data Protection Authority, the CNIL, imposed a 32 million euro fine on Amazon France Logistique, AFL, for implementing an excessively intrusive system used to monitor employee activity and performance. And this penalty amounted to nearly 3% of AFL's gross annual turnover. The excessive surveillance primarily affected warehouse workers and subjecting them to continuous scrutiny. And the CNIL determined that the data processing associated with this surveillance was disproportionate in relation to the workers' fundamental rights, including their rights to privacy and safe working conditions. The CNIL also highlighted the implications of extensive monitoring on employment law, the close and precise tracking of employees' whereabouts, such as whether they were in the office or at home on a particular day, could lead to stress, health issues, and even claims of constructive unfair dismissal or discrimination. And the CNIL suggested that aggregate data rather than granular real-time continuous monitoring data could achieve AFL's commercial aims without causing so much pressure on employees. While the monitoring practices at AFL were particularly extreme, the decision shows the importance of proportionality when relying on legitimate interest as a lawful basis and avoiding excessive or intrusive monitoring beyond employees' reasonable expectations. Now, this decision can be seen as a continuation of a trend of enforcement actions by the CNIL, which announced in November 2023 that it had imposed 10 new sanctions under its new simplified sanction procedure, addressing recurring concerns relating to video surveillance of employees and data minimisation. And if you want to read more about the CNIL's decision, Moira and our colleagues have written a really good blog on it, which we can send out along with the link to the recording later on. So over in the UK, more recently, the ICO issued an enforcement notice against Serco and associated community leisure trusts, which unlawfully processed the biometric data of more than 2,000 employees at its leisure facilities to monitor attendance at work. Now, the ICO's enforcement notice required Serco to stop all processing of biometric data for monitoring employee attendance and destroy all biometric data that they were not legally required to retain. Serco had failed to establish an appropriate lawful basis and special category personal data processing condition for the processing of biometric data. And the ICO considered that less intrusive means could have been used to monitor employee attendance. Serco had attempted to argue that manual sign-in sheets and ID cards were prone to human error and abuse, and that the attendance monitoring system was necessary for compliance with the employee's employment contracts. However, this argument failed to show why it was necessary or proportionate to use facial recognition technology and fingerprint scanning to monitor employees' attendance. Looking at the lawful basis, Serco had identified that its lawful basis was legitimate interest and contractual necessity. And although the ICO acknowledged that recording attendance times may be necessary to ensure employees were paid correctly for the time they had spent at work, it didn't follow that the processing of biometric data was necessary for that purpose. And with respect to the legitimate interest argument, the ICO explained that legitimate interest will not apply if a employer can reasonably achieve the same result in another less intrusive way. And in this case, Serco had not provided enough information to support its argument that no less intrusive means were available. I think the key takeaway here is that employers will need to show that they've considered less intrusive means and why those means could not reasonably achieve the same result. So the proposed monitoring must be more than just useful to the business and be a targeted and proportionate way of achieving that purpose. Looking at some enforcement through an employment lens, last July, a German court in the Higher Labour Court of Saxony found that data obtained from an access control system via a personalised chip which tracked employee entry and exit from the office could not serve as valid grounds for dismissal. The reason was that the access data was recorded without the employee's knowledge, and therefore, even though working time fraud was apparent in the case, the dismissal was found to be invalid. Where evidence from the employee monitoring is relied on in any disciplinary or dismissal process, therefore, you must be able to show that the employee was aware of the data being captured and that it could be used for this purpose. So that's all from us today. Thank you for tuning in. We'll circulate a link to the recording, and if you'd like to listen to this again at some point in the future, you'll be able to find the recording along with our other webinars on the Fieldfisher Silicon Valley YouTube channel. You can find Moira and our colleagues' blog on the CNIL's enforcement decision against Amazon over on the Fieldfisher website. And we also have our podcast where we do case updates, which you can find by searching Fieldfisher Data and Digital on your usual podcast channel. Next up in April, our team will be looking at the topic of automated decision making, and we'll send out further information on that closer to the time. But thank you again for joining us today, and hope you enjoy the rest of your day.